Assalamualaikum and hi, my name is SHARIFAH FARAH. I am from AM1104G. So I will go through to introduction. ASEAN is considered as the most successful multilateral organization in the ASEAN region, especially in maintaining regional security and peace. The key that separates ASEAN with others and allows it to maintain regional peace and cooperation is its unique diplomatic engagement with its member state, known as the ASEAN Way. The most important element of the ASEAN Way is the practice of the principle of non-interference among its member states. ASEAN members practice this principle since the founding of the organization, ensure state sovereignty that serve as expression of respect and equal standing for all member countries. Quiet diplomacy allows ASEAN leaders to communicate without bringing the discussion into the public view. ASEAN Way has been perceived as the main contributor to success and failure of ASEAN. The proponent of ASEAN Way argue that this decision-making process helps the member countries to respect each other and produce peace in the region. That's all from me. Thank you.
Hi, my name is FARHANA binti Muhammad SAUFFie. Now I will brief about mutual respect for the independence, sovereignty, equality, territorial integrity, and national identity of all nations. A hallmark of the Asian Way consensus guarantee that all member states, big or small, equal in Asian decision making. It is credit for bringing Asian members together and keeping them united. Being nation-state that had just thrown off colonial shackles, Asian countries embrace consensus as a twin brother of non-intervention to guard against in any potential infringement of their national sovereignty. However, ASEAN has evolved significantly from a loose association toward a more integrated community. Its rapid expansions to include all mainland Southeast Asian states in the 1990 further deepened diversity and complexities with the organization. While the other generation of Asian leaders had decided to cultivate their personal bonding, friendship, and mutual understanding, less time and political capital could be invested into forging friendship amongst today regional leaders. As a result, the sense of familiarity and give and take approach built up at the highest level is giving way to more entrenched national perspective to determinant of Asian United and the we feeling. Next, in the exercise of consensus, the line between preserving legitimate national interests and a free riding at the expenses of the region's overall interests is increasingly blurred and subjective. Building consensus has become a tall and order of sensitive security issues, such as the situation in Rakhine State. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Farah binti ZAIRI. For my part, I will talk about the right of every state to lead its national existence free from external interference, subversion and coercion. ASEAN founding fathers from Indonesia, Malaysia, the Philippines, Singapore and Thailand envisaged that without interference by external powers, countries in Southeast Asia would be able to concentrate on nation building, strengthen their societies and economies, as well as develop solidarity through regional cooperation. They intended to be an association of bind themselves together in friendship and cooperation through joint efforts and sacrifices to secure their peoples and posterity the blessings of peace, freedom and prosperity. On the other hand, Senior Official Committee, which is SOC, once recommended that TAC should be part of ZOCFAN, but TAC acquired a life of its own even though they are related. This is because the TAC's goals were to promote perpetual peace, everlasting unity and cooperation among the people, which would contribute to their strength, solidarity and closer relationship. TACs also obligate its signatories to settle disputes peacefully through consultation and aim to promote cooperation in many different areas with the objective of furthering economic development, peace and stability in Southeast Asia. Federal coercion refers to the power of the national government to ensure that its constituent states comply with their obligation under federal law. The ability of the federal government to coerce its subject appears as a theme in multiple debates during the period from the American Revolution to the Civil War, which is in 1776 until 1861. This includes discussion on the coercion of states, the enforcement of federal law, notably in the context of tax collection, the suppression of domestic insurrection, as well as the prevention of secession from the federal system. Furthermore, this principle refers to the favourite principle, which was already found in various ASEAN instruments, including national sovereignty, non-interference in the internal affairs of member states, and a non-confrontational approach, all of which have bearing on how human rights will be protected in the region. Despite its diversity, ASEAN has managed to be united and has maintained peace, security and stability in the region.
Thirdly, the alternative way on how ASEAN members ensure decisions are made through consensus is non-interferences in the internal affairs of one another, in which the principle of non-interferences members in internal affairs was explicitly referred to as one of the association's fundamental principles, while the principle of non-interferences is adopted by many organizations throughout the world and is enshrined in the Charter of the UN. What appears to be unique to ASEAN conduct of regional relations is therefore not merely the adoption of non-interferences as a behavioral norm, but rather its understanding and subsequent practice of the norm. This broad interpretation led the non-interferences policy function as an encouragement for the prevention of any acts by ASEAN member states that would possibly undermine the authority of the dominant political elite and upset domestic governance in any way of the member states. Sometimes referred to as the ASEAN Way, and these factors are important for understanding of why ASEAN has used the non-interferences principle as a guiding light. Is it therefore to be doubted whether the inconsistent application of the principle has necessarily undermined the principal function as the guideline like or ASEAN conduct in regional affairs. ASEAN is not interferences in the internal affairs of one another because its member states share a belief that domestic issues shall be managed domestically since they have sufficient state strength to do so. ASEAN member state has a shared understanding that state strength enables them to solve their domestic issue without relying on or being compelled to rely on ASEAN for the purpose. That's all for me. Thank you.
Next, alternative ways on how Asian member ensures decisions are made through consensus is settlement of differences or disputes by peaceful manner. The original 1967 Bangkok Declaration that founded ASEAN made no provision for institutions of any sort beyond a regular meeting of the foreign ministers. In the 40 years after the Bangkok Declaration, ASEAN functioned on an informal basis as far as law was concerned. The Charter was designed to create the legal framework for ASEAN as a rules-based organization. The framework for the settlement of disputes is to be found in Chapter 7 of the Charter. To recapitulate, disputes which do not concern the interpretation or application of any Asian instrument are to be resolved in accordance with the Treaty of Amity and Cooperation in Southeast Asia, TAC. Economic disputes will be settled by recourse to the Asian Protocol on Enhanced Dispute Settlement Mechanism, the Vientiane Protocol. As for other sorts of disputes, it is specifically stated in Article 22 that dispute settlement mechanisms must be established in all fields of Asian cooperation. In pursuance of this, a high-level experts group, HLEG, was set up and tasked with fleshing out the dispute settlement mechanism. The HLEG's recommendations resulted in the Protocol to the Asian Charter on Dispute Settlement Mechanisms, signed by the foreign ministers of the Asian states on 8 April 2010 in Hanoi. The DSM Protocol is meant to fill the gaps where the TAC and Vientiane Protocol do not apply.
Hi, Assalamualaikum. My name is AISHAH BINTI OTHAMAN. Now I will present about renunciation of the threat or use of force. Okay, the threat or use of force is renounced. They must work together effectively in the event of a dispute over things directly affecting them. They shall refrain from the threat or use of force and shall resolve such disputes through amicable dialogue all times. Force and threat have long been associated with international relations. The history of political philosophy, in particular, has been highlighted as a critical component. War was regarded as a common occurrence, a fact that was neither sanctioned nor prohibited by law. The occurrence was simply counted on as a means of administering power, leading Turkey to conclude the state interactions were founded on force rather than law and morals. Views in the theory of international relations were formed on the ideological foundation. Undoubtedly, a centuries-old domination of politics over the law contributed to this, which has not evaporated even if there has been a trend for a century to submit politics to the law, at least to the amount necessary to protect humanity's highest ideals such as peace and security. Force has been used for many purposes in the international community, which is characterized by a high degree of decentralization, both of previous actions of pressure, intervention, and ex post factor for punishment due to non-performance according to demand sanction. The most extreme form of warfare was commonly used to seize parts of a country or completely subjugate a state. While reprisals have always been seen as legal violence, There was no single point of view on war. According to one point of view, war was regarded as a legitimate political tool stemming from sovereignty rather than a delay or sanction. However, it would be a mistake to suppose that war was a petty toward war and the calamities that is brought about the best evidence on which are attempts to justify recourse to war from antiquity to the present day. Even the ancient East inhabitants were aware of the distinction between defensive and aggressive, or fair and unjust battles. Great writers and philosophers despised war, while statesmen look for reason to justify wars and to assign blame for starting a conflict. Victorious countries have even tried belligerent countries' leaders to war crimes. For example, in Rome, the distinction between just and unjust wars was refined, but the criterion was entirely formal because the rigid procedure for declaring war was in dispute. In essence, unjust war could be legally sanctioned. As a result, the distinction between just and unjust wars was morphing into or nearing that of acceptable and probably heated conflicts. Several viewpoints emerged in the Middle Ages, all of which were closely linked to the actual social ties of the time. While in exile, Christianity viewed all forms of force, including wars, to be immoral and oppose military duty. When it became a state religion, it changed its attitude towards war, leading to the formulation of Saint Augustine's thesis of legitimate war against non-law. War was considered both a normal and a non-normal state in Byzantium. It was always righteous to wage war against non-Christians. According to Islamic theology, combat is justified only against heretics and infidels.
Hi, Assalamualaikum. My name is Siti SATAR and I will continue the presentation today. So, my part is effectiveness of cooperation among themselves. So, first of all, we have mindful convinced of the existence of mutual interests and common problems among Southeast Asian countries, and convinced of the need to strengthen the existing bonds of regional solidarity and cooperation. The second one is desire to lay a solid foundation for joint action to promote regional cooperation in Southeast Asia in the spirit of equality and partnership, and thus contribute to the region's peace, progress, and prosperity. The third one is consists that in increasingly independent world, the cherished ideal of peace, freedom, social justice, and economic well-being can be best realized by fostering and good understanding, good neighborliness, and meaningful cooperation among the countries of the region that are already linked by historical and cultural ties. Next, we have considering that the countries of South Asia bear primary responsibility for the region's economic and social stability, as well as for ensuring peaceful and progressive national development, and that they are determined to protect their stability and security from any form manifestation of external interference in order to preserve their national identities in accordance with their people's ideals and aspirations. Apart from that, affirming that all foreign based on temporary and only remain with the express consent of the countries concerned, and that they are not intended to be used directly or indirectly to undermine the national independence and freedom of states in the area, or to obstruct the orderly development of their countries. Although ASEAN states cooperate mostly on economic and social matters, the organization has a security function with a long-discussed program for confidence-building measures, according to Singapore's Foreign Minister and Thailand Foreign Minister. That's all from me. Thank you.
The ASEAN Charter is an ambitious document. In the article of the Charter, restates ASEAN's commitment to reliance on peaceful settlement of disputes as one of the governing principles of the organization. Adherence to the rule of law as an aspirational goal is so important that it is stated thrice in the Charter, in the preamble as one of the purposes of ASEAN and as a governing principle. It is easy for the cynic to characterize all this as empty rhetoric, but aspirations are important for ASEAN. They provide a goal to aim for. The transformation of ASEAN into a rules-based organization is a generational project. Progress may be slow, but there is movement in the right direction. One should not expect that progress will be linear. Backsliding will occur. The public affirmation of rule of law and peaceful settlement of disputes as core principles of ASEAN allows peer pressure to be brought upon a member state that strays from the declined norm. That is the nature of diplomacy. It should never be forgotten that the resolution of disputes between countries is a matter of diplomacy more than law.
As the conclusion, it is necessary to clarify that ASEAN is not intended to formally act as a third party mediator in disputes involving its member states unless it has ascribed to do so, or asked to do so by the member states in order to properly understand and assess what ASEAN does and could possibly do in terms of conflict management. Instead, the association envision itself as a tool for improving relations among its member states. This is accomplished by establishing favorable conditions for enhanced engagement through ASEAN-wide cooperation. Another role that ASEAN may play in the creation and implementation of mechanisms that member states can use to resolve their disputes. ASEAN can also define rules for how its member state should interact with another, as seen by the Declaration of ASEAN Concord, the TAC of 1976. And the Declaration of ASEAN Concord II of 2003, as well as the 2007 ASEAN Charter. The proposed ASC will strengthen existing concepts and methods while also attempting to build new ones. Another key feature is that member states are prohibited from engaging in internal conflicts in other member states under the principle of non-interference in the internal affairs of other states. This means that ASEAN selected member states and individual member states can only interfere if a member state asks for aid or intervention. Depending on the request and the role that ASEAN or its member states are willing to play. The nature of such involvement may vary. It also worth noting that the ASEAN method to conflict resolution is focused at interstate conflict rather than intra-state conflict. This is best understood by considering the historical background in which ASEAN was formed, as well as the critical significance or the leaders of the time to ensure their political survival in the face of major domestic threats. Thank you.